Hi, my name is Deborah Niven and I'm an intellectual property partner at Gunnar Cook. I also advise clients on data protection, and here are my 3 reasons why it is important to have your data protection in order. Number 1, there are many potential ramifications of failed privacy and data protection, including adverse publicity, potentially leading to reputational damage and lost customer trust, prosecution or regulatory enforcement action against the company, which can result in substantial penalties depending on whether you are the controller or the processor. There could be sanctions including criminal liability for directors and senior managers, and increased scrutiny from regulators whose confidence and powers are increasing. Unfortunately, you could also be subject to a civil liability action for violation of employment laws and becoming embroiled in litigation, and its attendant time, effort and expense is not what you need. But number 2, carrying out an audit of your current practices, systems and processes doesn't have to be hard. You can carry out an audit which will look at the business as a whole, what processing is carried out and by whom, internally or by suppliers. You should check legal documents to ensure you have appropriate data protection clauses, and also check whether suppliers are processing personal data in accordance with UK GDPR, or even whether they process data outside the EEA, in which case special provisions will apply. Number 3, you can follow practical steps to ensure you are complying with data protection legislation, and also importantly that you can demonstrate that to the ICO should you need to. You will need internal regulatory compliance, such as a committee to keep abreast of changing laws, and you should work towards compliance, including any remediation that needs to be done. I know businesses have to strike a balance when addressing this area. On the one hand, information assets must be used effectively for your firm to be successful, while on the other, various standards need to be met, arising from not only regulatory requirements but also customer and employee expectations. This balancing exercise needs to take account of many factors, including regulation at a variety of levels, from board level down to every employee in your business. PDP law and practice varies significantly from country to country, and many businesses need to operate beyond the borders of their home jurisdiction. So in summary, I would look at direct marketing to ensure that you have the necessary consents in place, that you have privacy policies and notices in place. If you're using biometric data, this needs to be dealt with as a special category of data. If you have any offshore activities, ensure that the offshore criteria is met, and also look at outsourcing and how your suppliers deal with data. Thank you.